Fantastic. Okay, well, welcome everybody to today's webinar. I'm Alex Solo. I'm the co-founder of Sprintlaw, and today we're going to be talking about starting your online business, the legal essentials. Before we get into the legal content for the day, just a quick introduction to Sprintlaw for those that don't know us already. We're an online law firm really designed to make legal services simple, affordable, accessible for startups and small businesses. Unlike traditional lawyers, we don't charge by the hour. We do fixed price legal services covering most of the areas of law that you might need help with, anything from sort of setting up a company, protecting your intellectual property, employment law, data and privacy, contracts, e-commerce, which we're going to be talking obviously a bit about today, and pretty much anything else. We have an optional membership subscription and software, which about 90% of our clients sign up to, and it's got a ton of features. There's a free tier for anyone that wants to just check it out. You can make your own free legal documents. If you're a paid member, book in consults with our lawyers. We've got some AI features, e-signatures features, and a great tool to monitor your ongoing legal requirements. A bit more about us. We've been around for about 8 years. We were founded in Australia, but have expanded to New Zealand and the UK as well. Fast-growing team, won lots of industry awards. So if you're not working with us already, there is no time like the present. And if off the back of today's presentation, you are in need of some legal help or want to get a quote for any of our services, we do free consults. So you can book a chat with our team. We'll drop the link in the chat as well. And I'll show this QR code at the end. So for today's presentation, we're going to be, as I mentioned, focusing on legal requirements for online business. For those of you running an online business, setting one up or running it for a little while, we'll talk a little bit about the right kinds of business structures to use to run your online business. We'll then talk through some regulations covering how you can present and market your services online. We'll talk about intellectual property, what you might want to protect, and how the law works around using others' intellectual property online. We'll talk about key contracts, terms and conditions that you may want to get in place, and data and privacy. As I'm going through, do feel free to drop questions using Zoom's chat feature. I will, I think it's the Q&A feature rather. I will keep an eye on it and try and answer as I go. And also, if we get time, we'll kind of cover off some other questions at the end as well. Before though we get into the kind of content, legal content for today, I just wanted to talk a little bit about more philosophically when a business should be thinking about getting legal help. And this is particularly relevant to online businesses or businesses operating online. I think more and more people are, using online templates and ChatGPT and other such tools to get answers to simple legal questions. The cost of lawyers can be prohibitive. And so you have to make a decision, when am I going to figure this out myself and when am I going to get proper advice and support for it? And I think some lawyers will tell you, every little problem you need to spend a ton of money and pay the big bucks for lawyers to fix it. We try and help the smaller businesses be a little bit more pragmatic. And I think if you're running a business, what you want to kind of first understand is, what is the point of legal help? What does it do for your business? One of the main reasons people use lawyers is for risk management. So, it's to prevent against something going wrong in your business. Maybe it's your contract that protects you from being sued if something goes wrong with the client. Maybe it's your supplier agreement, which makes sure that if your supplier doesn't deliver things on time, you have certain recourse. Maybe it's the setup of your business structure, which we'll talk about in a moment, that again protects your personal assets from liability. Maybe it's compliance things that stops you getting fined or being issued penalties by the government. These are risks that come with business. Things can go wrong and you can suffer consequences. And lawyers have ways to help you reduce those risks, often through disclaimers, contracts, and advice on how to structure things better. So there are tons of risk in business. Big companies have the luxury of having internal legal teams who can cover off every single one of their risks with policies and documents and procedures. Smaller businesses don't have that. And so you got to figure out when am I going to go get legal help and what for. And I think this matrix is a useful way of thinking about it. If you think about the particular risk that you're dealing with, how big an issue would it be if something went wrong, and how likely is it that something is going to eventually go wrong? And the closer we are to that top corner, the more you want to invest in legal advice. And the things in the bottom left corner, negligible risk and unlikely to happen. You may not necessarily need to spend the big bucks on getting legal help for it. And for your business, it will depend on what you do and what you're selling in terms of what falls into which bucket. But you might think, for example, like having, if you're a team of 3 people, having your social media policy document, might not be the biggest deal because an issue with one of your team members using social media wrong, query what the actual consequence could be and how likely it is to happen when you're a small team. Now, I mean, that may depend on what your business does. If you're putting a lot of products online and you're using other people's content that we'll talk about later, then maybe for your business, the risk of something going wrong in your small team is a bit higher, and you want to get some advice on what social media guidelines would look like. But for many businesses, that might be a pretty low risk document that you could generate yourself without needing legal help. On the other hand, your client agreement, the agreement that you use to sell your products or services to all of your clients, and for many online businesses, that's your terms and conditions at checkout. Eventually, you're going to have some issues with your clients, so the likelihood of risk is pretty high. And depending on what you're selling, the consequence of those risks could be pretty serious. So people that are sort of DIYing their core customer terms and conditions or not getting help on that, I think that's an area where you might want to make sure that everything is done correctly, because again, pretty likely something will eventually go wrong with the customer, and if the risk could be severe to your business, you don't want to be relying on things you've done yourself. So it's a useful framework to think about, and as I'm going through and talking about different legal issues, you can be thinking about your business and what the risks are. And again, the more stuff in the top right corner that you have is really where you want to be focusing your legal attention. The other thing just to quickly mention is lawyers aren't just about risk management. We do help people also get good deals, particularly for things like referral arrangements or, the way that you set out your customer terms and conditions. We've just drafted lots and lots of different types of documents. So, in terms and conditions, for example, lawyers can be very clever with payment clauses. What happens if someone doesn't pay on time? How do we incentivize them to pay on time? Do we have late fees? Or in your supplier arrangements, if you're engaging a software developer or something like that, again, if you could just sign what you're given, or you could get a lawyer involved, and maybe you'll get a contract negotiated that entitles you to free bug fixes, a warranty period, milestone payments, and you're not left paying a developer for work that they haven't fully delivered. So it's not just about risk; it can be about better commercial arrangements. And again, if you're doing important deals, whether it's with business partners or suppliers or partners or whatever it is, that's another time to go, okay, this one's pretty important deal. I might want to go see a lawyer about it. So yeah, just wanted to sort of start with that. But now let's move into business structures. So we're going to talk a little bit about how to set up your business correctly if you're running an online business. And when we're talking about online business, we're talking about any business that's providing goods or services online. So maybe you're an e-commerce shop, maybe you're an online consulting business that delivers your services online. Maybe you're an offline and online business that you've got a shop, but you also are doing things online. That's the sort of businesses I'm going to be focusing on in today's presentation. And maybe you're an offline business, but you do some things online. You have a website, you have a blog. We'll also talk about some issues for you there as well. So for most small businesses that are operating online, when you register your business, you'll have to choose a business structure. And a business structure in Australia is compulsory for anyone that's trying to make revenue from goods and services. Unless it's like a hobby, very small scale, you really need a registration of some description. The basic decision that you make is between setting up as a sole trader, which you can just sort of go online, do yourself, instant with ABR. It's pretty straightforward. and you can get that Australian business number, which is a sort of registration number. You can then go out and do business under your personal name. If you want to have a business name, you can register something called a business name against your sole trader, and you can sort of run a business in that fashion as a sole trader with a registered business name and an ABN number. Go out, sell stuff to clients, sell services, sell goods, and put that ABN number on your documents. And that's a way to operate a business. Lawyers, however, don't really like that structure very much. One of the main reasons we don't like the sole trader structure is if something goes wrong in your business, there's an issue with your goods, there's an issue with your services, a client is unhappy with you, they decide to make a claim against you, you're ultimately personally liable for the issues that occur in your business if you're a sole trader. When you're a sole trader, you are still an individual doing business with other people, and there's not a clear separation between your personal life and your business life. That means if something goes wrong in your business as a sole trader, people can come after you, your assets, your house, your home, your car, whatever other things that you might own. On the other hand, there is a structure called a company structure, which people would have heard of, which for smaller businesses, the most common version of it is the proprietary limited structure. And when you set up a company, what you're essentially doing is setting up a separate legal person from yourself. So rather than you, the individual running the business, there is another fictional person called the company. It has its own name. It has its own bank accounts. It can sign documents. It will have these people called directors who are sort of like the mind and the arms of the company, who can kind of control it, control what it does. And it'll have shareholders who are sort of like the body of the company. They own it, and they can choose, who controls it. But ultimately, it's a separate person. So it can get sued. It runs the business. It can do things. And in most cases, if something goes wrong, only the company's bank account, the company's assets are on the line. But not the people behind it, the directors and shareholders are in most cases, and there are exceptions in the case of fraud and other such things, but in most cases, the liability of the business is limited to the company. That's why we call it a limited company. So you can see why we as lawyers who are in the business of helping you manage risk really like the company structure. It seems like a thing that's for bigger businesses, but really, if you can afford it, and to set up a single company costs something like $600 to $900 in Australia, then there's $200 a year in renewal fees and an extra tax return you have to do. So it's not nothing, but it's not diabolically expensive. Once you have that structure, you have a lot of comfort in your business because you know that worst comes to worst, the company gets sued, you, the individual behind it, are protected. So I generally recommend most businesses that are serious consider a company structure. Certainly if there's more than one person involved in the business, you can do something called a partnership, which I don't have on screen, but it's kind of like multiple sole traders working together. A partnership in a registration sense is not a great structure. Like most lawyers don't like that either, because again, if something goes wrong in the partnership, the partners are liable personally. If it's a 50-50 partnership, the partners are liable. 50%, their house and their home and their assets are liable 50% in most cases, versus if they operate through a company and the business partners are set up as shareholders with a 50% shareholding in a company, again, the liability is all limited to the company, and it's a much better way to do business with others as well. There's tax advantages and various other things as well, depending on your personal circumstance. So again, if you're small scale, you're doing something really in the bottom left corner where there's risks are quite unlikely, you might choose a sole trader structure. But if you want to sleep easy at night, the company structure is a really great way to reduce a lot of that risk because you've got the limited liability. Jared's asked a good question. How about mitigating sole trader risk by way of public liability and professional indemnity insurances? That's a great point. That is what I say to a lot of sole traders. I say, look, best practice is have a company. If you're not ready for that yet, or you don't want the expense and complexity of it, at least consider getting that insurance that you've mentioned there, insurance for your business. Because if you're a sole trader with business insurance, something goes wrong in the business, legally, you're personally liable. But if you've got insurance, you can always call your insurance, say, hey, I've been subject to a claim, will you cover me? Now, people that understand how insurance works knows that there's a policy, there's exceptions to the policy, there's limits to the policy. And so an insurance is not as good as a company structure, which actually legally limits your liability by law in most cases from any liability. There is a full shield between you and the end customer and you as a person. So it's stronger to have a company, but an insurance is better than nothing, if that makes sense. And of course, even better is a company with insurance. Um, so um, if you if you and of course, at Sprintlaw, when we first set up being lawyers, one of the first things we did was set up a company and get our business insurances. So that's kind of the best practice in terms of risk management. Um, Vanessa has asked a question. How easy is it if we're already registered as a sole trader to then change to a company structure, or do we need to dissolve and register again from scratch? It's legally not difficult. You would just register a company if you're a sole trader, a new company, and then you just start doing business out of that company. You would update your contracts and those sorts of things. It's administratively, it's more of an administrative question than a legal question. Like if you've got a bank account in your personal name, you would need to set up a bank account in your company's name, which means you need to go to the bank and ask them to set up a company bank account. They're going to ask for a whole bunch of documentation. So there's a little bit of administration there. If you've already signed up to various things under your sole trader ABN, maybe it's software subscriptions and so on, you would move that over to the company. You might want to get an accountant for the company. So it's admin that you would need to do. You essentially are separating your personal life from your company life. So those are the sorts of steps that we're talking about. And depending on how far, if you've just started your business and it's not that complicated, what I just said is not that hard. But if you've signed tons of agreements, signed up to tons of things, and moving it across to the company is a big deal, then it's a bit more work. So yes, if you own assets and stock, you might have to transfer them to the company. If you're thinking it's a bit complex, I would suggest chatting to a lawyer and/or accountant about the move. But as I said, if it's pretty straightforward, it's just about setting up that new company and moving stuff across. Charles has asked, could you talk about co-ops? That's not probably going to be covered in today's session. I'm also not an expert on co-ops. If you do have questions on co-ops, you're welcome to reach out to our team and we can get one of our lawyers that knows about co-ops to talk about that in a bit more detail. Jared's also asked, under what circumstances can directors and shareholders be held liable, which is a great question. As I mentioned earlier, in most cases, when you have a company structure, the people behind it are protected from liability, the owners. Shareholders are very, very rarely liable. Directors are the ones that can be liable. When you set up a company and you appoint yourself as a director, i.e. the person that can control the company, sign off on the documents, direct this fictional legal person what to do. So if you're the owner, you're usually the director, at the beginning at least. If you breach one of those director's duties, which are given at the time of setting up a company, and there's sort of 6 duties that you have as a director under the Corporations Act. They're things like, you must exercise your position with due care and skill, not use the company for an improper purpose, avoid conflicts of interest, and there's things preventing you from committing fraud. These are circumstances where you can think of it colloquially. If you start doing dodgy things through the company to avoid risk, if you start moving money in a way so as to avoid tax and benefit yourself, you could breach these duties. And in those circumstances, the courts will sometimes what they call pierce the corporate veil and look at holding directors liable. So you can't do really dodgy stuff, but as long as you're running a business in the ordinary course in good faith, you're generally not liable for anything. And again, there's tons of great resources on directors' duties on ASIC's website. It's a well-documented area, so you can understand those risks. And as I said, for most businesses that are operating fairly ethically, it's not a big deal. You can get a special insurance called directors and D&O insurance, directors and officers insurance, which is another insurance, which in the event that directors are found liable, it will step in and protect you. So it's another layer of protection for that risk. But that's sort of how that liability works. Getting some good questions here. I might skip to the next slide so we keep things moving, but I might just deal with one more. Vanessa's asked, how does it affect contracts signed as a sole trader after changing to a company? Look, technically what you should do if you've signed something as a sole trader is you should speak to whoever the other party is and just say, hey, I've set up a company. Can we move the contract over to my company? And then you might just get it re-signed with your company, or you can do something called a novation agreement, which is a one-page document that just transfers the contract. Depending on what the contract is, if it's your like a subscription to a Microsoft Office license or something, it might not be the biggest deal. Although you might want the invoices now made out to your company. But technically, the way to move the contracts, as I said, is re-sign it or get it transferred under a novation agreement. We've had a question on trust setups. I've got this slide, so it's a good segue to talk about my next slide. These two structures, the sole trader and the company structure, are the kind of straightforward structures. There are more complex structures out there that you can use to operate your business. I won't spend a ton of time on this because I've talked about this in previous presentations. And for those interested in learning more about this, there's a recording online. We did a presentation a couple of months ago on company structures, talking about this in detail. But just to explain, you can operate under a single company structure. That's by far the most common structure for smaller online businesses. Growing businesses that might want to raise funding, businesses that are going to be generating significant revenues in the future, may consider a dual company structure or a trust structure. And I've got a visual representation of these on screen. And Sprintlaw, for example, operates with this structure on the right. To explain what these structures are, when you register a single company, as I mentioned, the owners are generally protected from liability from your end customers. If there's an issue with the customer, they can make a claim against the company. But as I said, the directors / shareholders sitting behind it are generally protected by the company. But over time, if your company becomes valuable, that limitation might be good, but not great, because a lot of your cash and assets are actually in your company, and you might want to protect those further. So you can set up this dual company structure, which we have in the middle here, where you set up two companies, an operating company, and this is the company that goes out and deals with clients, signs contracts, kind of runs the day-to-day of your business, does all the risky things that happen in business. It's actually owned by another company called your holding company, which owns all of your valuable intellectual property, your brand. If you've got software that you've developed, the software, it can even hold cash reserves as well. And that one is owned by the owners. And that means if there's an issue down here in the operating company, an employee has an issue, a client has an issue, they decide to sue your operating company. The operating company could be liable, but all of your valuable assets in your holding company would be protected under that same principle of limited liability. This person would only have a relationship with this company, and your holding company could act as a safety deposit box, sort of holding those key assets. So larger businesses often like setting up this two-level structure. It also means you can set up more entities in future and essentially silo your risks to different companies. So for example, Sprintlaw has Sprintlaw Group, which is our holding company. We have Sprintlaw UK, we have Sprintlaw Australia, we have Sprintlaw Tech, which is like a tech company. If something goes wrong in our UK business, which is its own entity, the client would have a claim against the UK business, but they've got no claim against our holding company and no claim against our Australian company. So we've really siloed the risk of that area of the business here. So this structure can be useful if your business is doing 4 or 5 different things, you're expanding internationally, or again, you just want to silo that risk. It's expensive. You got to set up 2 companies. You got double the tax returns. Again, we're talking $1,000 per company. And then, the $200 renewals and the extra tax returns. So that's the quantum. So, for the risk protection, depending on what you're doing, it can really be worth it. But again, if you're a small business, it's probably overkill to have the dual company structure unless you want to scale up or have some really important assets. On the right, we've got the trust structure. We've still got the dual company structure down the bottom, but you can see there's some different stuff going on up the top. And basically, the owners of the holding company, instead of owning their shares personally, their stake in the company personally, they've set up these trust companies to hold their shares. Now, there's a couple of reasons people do this. I've talked a lot about how down here, if there's clients, something goes wrong in the business, the clients can sue only the operating company or the company, but they can't come after the business owners. But up here, if there's one or more business partners and or investors, these people would have personal relationships with each other. They would be shareholders with each other, and they might sign a document called a shareholders agreement or a business partners agreement. So whilst these people are protected from liability from the customers and the employees, as it pertains to each other, they have personal contracts with each other. And so founder two could potentially sue founder one for their house and home, even though we're in a company context, because the company doesn't sit between the two owners of the company, if that makes sense. So when you have a trust company, you've now added another layer of protection. As you can see, a lot of protection for founder one. Founder one is obviously protected from the employees, from the customers, and also protected from other founders because there's a trust company sitting in between them and the other founders. So if there's a dispute between business partners, again, the founders' personal assets are again protected. So that's one of the advantages of the trust structure. It's another layer of protection. We use a trust instead of a company for a couple of reasons. There can be certain tax advantages depending on what you're doing with the funds that flow out of your company to use a trust. That does depend on your personal circumstances, but it is a reason a lot of people use the trust structure. And again, if you're considering that structure, usually better for businesses making a decent amount of income, worth a chat with your accountant, and they can come up with the right version of the trust structure for your particular situation. But this is kind of how it fits in. It's not about the way your business operates. It's more about how you hold your stake in the business, which you can do through a trust. So hopefully that makes some sense. As I said, I've got another video going through this in a bit more detail, and our team are obviously happy to chat if you have more trust questions. But a moral of the story is, if you are not already operating through a company, do consider it. It's a really great way to protect yourself from liability. And I just saw we had a question. And liability risk for directors of a company who are also founders. It's pretty much the same thing. Founder is not really a legal term. It's more of a colloquial term. In legal terms, when a company is set up, it will have these people called directors and these people called shareholders. The shareholders own the company, the directors control the company. Founders are usually both because they not only do they own it, they control it, at least when they start the business. So you would have all the risks that a director has. Shareholders generally don't have that many risks and are very, very rarely personally liable unless they do something fraudulent in relation to their shareholding. But director, you'd have the same risks as directors if you were sort of a founder of a company. Okay, so just moving on past company structuring, you got your business set up. You're going to be operating your business online. I just want to cover some of the key laws and regulations that you want to have in the back of your mind when you're operating your business online. So in Australia, we have an important law that pretty much every business needs to be aware of. And it's the law of misleading and deceptive conduct. It exists in a few places in the law, but most notably in the Australian consumer laws and the Competition and Consumer Act. And the law basically says it's illegal for businesses to engage in conduct that misleads or deceives or is likely to mislead or deceive. That's a very broad sentence. What does mislead or deceive mean? Obviously, we all make sales pitches. What constitutes, though, the definition of misleading or deceptive, and how do we figure that out? So there's lots of different examples of what might be misleading, and I'll go through a couple on the following slides, but this is one of the biggest issues businesses face operating online in the way that they market themselves, in the way that they set up their website and social media ads they do. It's that balancing act between trying to promote your business but not going so far as to breach this law. And if you breach this law, you can be fined, there can be penalties, you can be sued by customers, et cetera, et cetera. So it's a pretty powerful customer protection law. And Australia actually has one of the most powerful consumer protection regimes in the world. A lot of the rights we have for consumers don't exist in places like the US. The UK does have relatively similar laws, although not as far-reaching in some ways as the Australian laws. So things you might see online or you might see happen on TV, might actually not be legal in this country. So it is worth being aware of this law, kind of burned into the back of your mind when you're running a business. When I'm promoting myself, I got to make sure I'm not being misleading or deceptive. Now, the legal definition is, would a reasonable person be misled or deceived by this activity? Um, what is a reasonable person? And what does misleading and deceptive mean? Again, these terms are not well defined in the law, so it is a bit grey, and judgment is required. And often when we as lawyers are giving advice on someone's proposed marketing activity or business plan, we'll just say, we recommend you add these words and disclaimers to reduce the risk of it being misleading and deceptive. All you can ever do is reduce the risk. It's not black and white, and it ultimately is up for debate. But you just want to be careful around this stuff, because this is the number one source of complaints. Jared's asked, what Act law are you referring to? It's the Australian consumer laws, I guess, which are our consumer protection laws in Australia. And if you Google ACL or Australian consumer laws, you can find information around which laws I'm talking about when I talk about misleading and deceptive conduct. So for your business, pretty much every business needs to abide by these consumer laws, and in particular, these laws around misleading and deceptive conduct. In addition, depending on what industry you're in, there might be some specific regulations. If you're selling health products online, you might need a registration with the TGA. If you're selling food products, you might need to comply with labeling requirements. If you're selling children's products, you might need to comply with specific health and safety regulations. Whatever it is that you're doing, you might want to, again, have a little bit of a search online for regulations that might apply to your type of product or service, because you also want to make sure you're complying with them. And usually if you're breaching regulations, and it depends on what regulation, there can be fines and penalties associated with it, and it can be business ending. So you just want to make sure you're not breaching any laws that you don't know about. The misleading one is general, but the industry-specific one depends on what you do. And I won't go through every industry, but I've given you some examples of some things for your industry. Just to give you a few examples of what do we mean by misleading and deceptive conduct. Well, we have an example here of a ad that Nurofen did. You can see on the left, it shows Nurofen with a chart, and beating your average paracetamol. Now, the average person looks at this and and thinks, oh, okay, Nurofen is just better than paracetamol. It seems to be faster, more effective, and there's a suggestion here with the chart that there's scientific research backing this. Now, there wasn't good science behind this. It was I think based on not well researched studies, and there was a $6 million fine for this marketing campaign for Reckitt Benckiser, who produced Nurofen. Now, fines of that quantum are probably not going to be issued to small businesses because they don't have quite the reach. But it's a good reference point. If you're putting together ads, you can see why somebody looks at this, concludes that there's some study saying that Nurofen's better than paracetamol. And if it turns out to not be true, or at least be misleading, and again, there was a report behind this, it just wasn't strongly backed by scientific research. This is the kind of stuff where we're saying, well, you've now misled a consumer. A couple of other examples we have here. Influencer marketing is something that people are doing more now. People are, you'll pay an influencer to post online about your business, saying, oh, this business is great, this product is great, this service is great. That's possible to do. The law does allow paid influencer marketing, but if you're getting the influencer to say false statements that are not true, in this case, we had a hotel chain paying an influencer tweet that she loves staying at one of their resorts, but they've never actually been there, then that tweet's going to be false, misleading, or deceptive. Now, that example is actually from the ACCC's website, so it's a clear example of what they view as misleading, to give you a flavor for what we're looking at. We've got another one, which is a real example. ACCC took action against a removalist business for misleading online reviews, basically testimonials, which they claimed were genuine, but they were fake, and had to pay. And this is a classic small business penalty, a $6,500 penalty. So that's the quantum probably for a smaller business that you might be looking at. But again, it can be from exaggerated copy that you use on your website, fake reviews, those sorts of things. So this is all stuff under that banner of misleading and deceptive conduct. Um, so zooming out a little more broadly to talk about social media and influencer marketing in general. For those of you doing stuff on social media or engaging in influencer marketing, this is a good checklist of kind of the legal issues that you want to be thinking about. First of all, if you are using sponsored content, for example, the influencer type marketing or other forms of marketing where you're paying for promotion, we've got these misleading and deceptive conduct laws. We need to comply with them. There's a couple of industry codes. They're not legally binding, but they give you the best practices for what you should be doing to not be misleading and deceptive. And to be able to say that you comply with the code is just good for your brand. So there's the AANA code, which is the Australian Association of National Advertisers. And it's got a very simple code, just a few pages, that talks about, hey, when you're marketing, follow these best practices. So again, if you're doing a reasonable amount of marketing and you're concerned about what you can and can't do, having a look at that code is not a bad starting point. There's also the more new AIM CO best practices. This is the Australian Influencer Marketing Council. For those of you doing influencer marketing, it has some best practices on how to get those sponsored disclosures happening, practices you should follow before paying for that kind of content to make sure it's not misleading. So again, for those of you doing sponsored content, definitely worth being aware of these laws and the best practices. We've got the ACCC guidelines. I've taken some screenshots from it. If you just Google ACCC social media, they're the regulators that would be fining you if you do misleading stuff. So always best to hear from the horse's mouth what they consider to be misleading, so you can have a look at some examples there. A couple of other issues to also mention, and I touched on this earlier, staff-generated content. If you have people in your organization generating social media content about your business, you just want to make sure, in the past, before ads went out, it was a little more tightly controlled because, a marketing team who might be aware of the issues at play, would maybe get things signed off by management and then send things out for ads, and you wouldn't have such a high volume of content being used to promote a business. Now we're seeing, with platforms like TikTok on the rise, a lot more higher volume of content being put out and a lot more people in an organization being involved in the generation of content for a business. So there's a couple of issues to think about. One is, of course, making sure that your staff are not saying anything that's misleading and deceptive. So you might want to do some education pieces around that. A second is making sure that you, the business, have the right to control what they're posting and own the intellectual property in stuff that they're creating. Usually that's covered by your employment agreement. And the third is ensuring that they're complying with intellectual property and privacy laws. And we'll talk about that a little more in a moment. But if you are getting staff to put stuff out broadly around your business, just be aware that it's not only at a business level that you've got to be aware of this misleading and deceptive stuff. You might actually have to train the staff a little bit on what they can and can't say and introduce some guidelines and policies around it. Finally, on the right, we've got using licensed music. Again, we see a lot of people posting online using music tracks or audio tracks in conjunction with their social media posts. The basic rule around using licensed music is if you're using like a well-known song or a song for which you haven't explicitly got permission, you could be in breach of the copyright of that original song. You could have to pay royalties to the owners. You could potentially be sued or held liable by the copyright owners for unauthorized use of their copyright. A lot of the time, it's best to use open source, royalty-free music if you can, and there's lots of websites like MusicBed, for example, which you pay a fee and they'll give you some music. People may have seen, obviously, on social media, YouTube and Instagram, people are able to publish videos sometimes with Taylor Swift songs or famous songs. And you might wonder, how is that possible? Obviously, Taylor Swift has not approved the use of her song in this social media post. The platforms the big platforms like YouTube, Instagram, and TikTok have done deals with the big artists, which allow them. They have a library of approved songs that they'll allow on their platforms. And then YouTube, for example, would have to pay the license fee anytime it's used on YouTube, and they have auto detection software that picks that up. So that that's how it works in practice, which is why you sometimes do see clearly famous songs used on social media. But rarely does YouTube have a license to allow that music to be used in conjunction with commercial content. If you tried to use it with commercial content, the algorithm probably it will block you. But if you manage to get it through the YouTube auto detect, you could be liable, to again Taylor Swift. If it was a snippet of a Taylor Swift song that you sneaked through and got into an ad, you could really be liable. So don't do that. Is the moral of the story, and ideally use that royalty-free stuff if you can. Vanessa's asking, Andy's asked, is the $6 million fine covered by their insurance? Also, did that marketing campaign bring in more than $6 million in profits? I mean, look, you raise an interesting question. I don't know if it's covered by their insurance. They probably didn't disclose that publicly. Perhaps it is. You are correct in that big businesses do think about legal through the lens of this square that I had. What's the risk? How big is the risk? And in this case, how big is the return? And maybe there was maybe a mildly unethical, or maybe not that mildly unethical business decision made here to put this ad up. Maybe they'll make more than the 6 million, and they'll be capped. My suspicion is the brand damage and other issues, from doing this sort of stuff. I mean, here we are talking about it in a webinar as an example of what not to do. Can't be great for the Neurophone band, makes this sort of stuff not worth it. Maybe a bit of a cheeky point, but yes, I think it's hard to know how the numbers played out for Neurophone in that case. Vanessa's asked, if a salesperson misleads someone against the training we're given, are they individually liable, or is it still the business because they're a representative of the business? Look, it's usually the business that's liable if the salesperson is representing the business under the principle of vicarious liability. Of course, individuals can be liable to their employer if they're intentionally breaching the requirements of their employment contract. Obviously, if the employee is committing fraud or trying to damage the business by intentionally doing things they don't have permission to, they can potentially be individually liable. So they don't have zero liability. But in most cases, if they are, unless they are, flagrantly ignoring the training, it's pretty rare for the person to be personally liable. And again, it's usually a business problem. Alison said, what you're saying about music licensing applies to photo, images, video, and any sort of creative. Will you be covering this too? Yes, we'll talk about that a little bit, which is a good pivot to this slide. So intellectual property is an area that, again, if you're running a business online, you just want to have a good understanding of what is intellectual property, what do I need to protect for my business, and what intellectual property do I need to be careful about using in my business. So in small business land, there's sort of 4 types of intellectual property that you want to be aware of. Now, I should be careful because if anyone here is a lawyer, you might correct me in that domain name registrations and NDAs, which we'll talk about, are technically not under the legal definition of what intellectual property is, but I think colloquially for most businesses, this is the area that you might think about these sorts of things in. So the first, to start from the left, is you want to make sure you own your business's brand and domain name ideally, and you want to be getting that early on for your business. A trademark is a registration you can do to protect your brand. Very important point, it's different to your company name or your business name registration that you might have done when you set up your business. A lot of people think, oh, I set up my business, I registered my business name, I registered my company name, I own my name. You don't own your name, you've just sort of ticked a box for compliance to name the company. If Apple has a trademark to your name, or a big company has a trademark to your name, even though you got it through, if I started a company called MacBook Pty Ltd, maybe no one started a company called MacBook Pty Ltd, so I could get it through the registration, but Apple could sue me for being out there training using one of their protected brands MacBook. So there is a difference between a business name or a company name and a brand. Generally, you want to own your brand. You want to make sure you're not using a brand owned by someone else. Sprintlaw, for example, we own the word Sprintlaw and we own the little S shape in our logo. And that means, and we registered that in Australia, the UK, a few other countries in a particular industry, in the legal industry. So that means no one else in the legal industry can use the word Sprintlaw in association with a legal service or that little S shape. We have the exclusive right to use that in legal. Now, someone could start a restaurant or a cafe called Sprint Slaw that sells coleslaw, and it's pretty similar to Sprintlaw, but it's in a different industry. That would be fine, probably. But if someone started a business called Sprint Legal or Sprint Lawyer in the legal industry, we could say, no, that's too similar to our trademark. So it doesn't just protect exact matches, it's anything similar to your brand and your space is protected. So first of all, you want to make sure you own it. You want to make sure that you're not inadvertently infringing someone else's trademark in naming your business or your products. And to register the trademark, if you're doing it in Australia, you go to IP Australia. There's a process to follow. It can take up to 8 months, and there's a chance for anyone else that owns a trademark to object to you getting it. And then once you've got it, it's a very strong thing to own. So, um, so in terms of what, again, best practices when we first set up Sprintlaw back in 2017, first thing we did was set up our company. Second thing we did was apply for the trademark because we didn't want to be out there building a brand for Sprintlaw until we were sure that we actually owned that trademark. So for those of you who haven't done the trademark yet for your business, I would suggest doing it. Now, you can't get a trademark for anything. Like if your business name is too generic, like if we tried to get a trademark for law firm, it would get rejected because it's too generic. It has to be distinctive enough. You may not be able to get one. There's a free tool on IP Australia's website called TM Checker, which gives you a bit of a sense as to your prospects of success. And of course, lawyers can help with the registration process, or you can attempt to do it yourself. But it's one of the most missed issues that we see for small businesses, and many of them, after a few years, maybe they get away with it, they start to do well. Someone else has the trademark, and they're forced to rebrand it. It can really be business ending. Jared's asked, what does it cost? It's about, if you do it with Sprintlaw, I think we charge about $1,000, including the government fees. If you do it yourself, I think it can be about $600, $700, just in government fees. So that gives you a bit of a sense. And again, if you do multiple industries and multiple trademarks, it can cost a bit more. So it can cost, maybe up to $1,500. And if you do multiple countries, it can get actually quite expensive in the thousands, but that gives you a bit of a ballpark. Nigel's asked, if you have a trademark in Australia registered, but you have an online business, can you show the R on the web pages even though products are being bought from overseas? That's an interesting question. If it's an Australian website just targeting Australian businesses and it happens to have a few people from overseas buying it, you're probably fine to use the R mark. If you're actively targeting, let's say, the US and you don't have the trademark there, it would actually depend on what the US law says. But my suspicion is there could be an issue, technically under US law, there could be an issue with using the R mark. Now, the R mark, I've got that on screen here, these two icons. The R mark is only able to be used by people that have formally registered a trademark. There's a law about that in Australia. Now the TM mark is actually unregulated. So a lot of people just use the TM until they've properly got the registered version, then they swap to the R. So again, a solution, Nigel, could be to use that TM mark until such time as you got it registered in all the markets that you're in. But yeah, I think that's the answer to your question. But again, I'm not an expert in all the laws of various countries, so it probably depends a bit on how those countries allow the use of the R mark. Domain registrations are not a legal right, but again, I probably don't need to explain this in great detail, but another thing you want to do early on, and maybe the only point to make is, if you do intend to expand internationally and you might want some other domains, do think about buying them early on in your business. It doesn't cost that much, and it can be a real pain later on to get an international domain that you might want to use if someone else has registered it. And there's all kinds of squatters out there that go and register, find an Australian business with a domain, and then buy the .com or buy the .co.uk, and then almost blackmail you to pay the money to get that domain. Even if you have an Australian trademark, it helps, but there's a domain authority that stops some of this stuff, but it's not that straightforward to win back the domain. So that's probably the main point I wanted to make on that. So trademarks are about branding. Copyright, to touch on the question that we had a little bit earlier, copyright is another form of intellectual property. Unlike trademarks, it's not a thing that you go and register and get your R marks or whatever it is. We do have these C marks, but they're not a formal thing either. Copyright is a right that arises at law anytime we have an original work created that's recorded in material form. And what that piece of jargon means is, if you are creating something that falls within the banner of copyright, what copyright calls an original work, and these are things like literary works, dramatic works, musical works, novels, books, films, videos, screenplays, graphics. These things, when they are created, the author is automatically the owner. They don't have to register anything. Under the law of copyright, the author of an original work, provided it's original, and there's a legal definition of original, which is fuzzy, as many things are in law, but basically is this hasn't really been done before as an element of creativity. It's novel. Anytime something original is created, the author owns it. So what does that mean for you in business? Well, it means two things. First of all, if you are creating stuff or stuff is being created for your business, you want to make sure that you own it and you have the rights to it. If you're engaging a graphic designer to design graphics for you, design images, website layouts, and they're original, or you're getting music done for your business or video content created for your business or whatever it is, likely the author of that work owns it unless they sign something in writing, a contract with you, specifically saying, I hereby transfer my copyright in the stuff that I did to you, the business or the company. They actually still own it, and they can stop you using it, ask for payment for you to use it, et cetera, et cetera. So you just want to make sure anytime you are getting work created that you've got a contract. If you've got an employment agreement, it's usually fine because there's a clause in an employment agreement called, copyright assignment or IP assignment. I, the employee, agree to give all my copyright to the company. So that's usually fine. But if you're engaging non-employees, contractors under no contract or under some contract they've given you, you just want to carefully check that you own this stuff, because you're going to be using it and you don't want them coming along later and saying, oh, you can't use that anymore, or you owe me money, you never paid me for the right to use it. So copyright, there's not a government body you go to, but you protect it through these contracts and you make sure there's something in writing signed confirming that you own it. The second issue is using other people's copyright. And so, to promote your business, you might be out there publishing blog posts, making social media content, and you might be using other people's imagery or content or information. Now, the law basically says if you use a substantial part, again with the fuzzy definition, of somebody else's original copyright work, they can sue you for copyright infringement and say, no, you didn't pay me, you used my work without my permission. Plagiarism is not a legal concept, but copyright is a relevant concept. You've plagiarized me, you've infringed my copyright without paying me anything. I demand damages. And we see this a lot with people putting up a blog post using a photographer's image they found online. The photographer emails them and says, this is a reverse image, emails them and says, I demand $1,000 because you've used my image without my consent, and this is an infringement of my copyright. And they're probably correct legally. So again, the solution to a lot of this stuff is only use stuff that you have the rights to use. Where possible, use these open source royalty-free things that give you the rights to use it for a fee usually. There are a few free royalty-free image websites like Unsplash, which has a lot of royalty-free images as well, so you can use things like that for imagery. But these are the ways people get around this. But just be careful that you don't put stuff not from those sources in any of your content, because again, you could be liable for copyright infringement. A few questions about this. Nigel's asked, can you use images from Canva on your work? Can you leave a footnote that the image from Canva, and does that cover you? Canva, I would have to look at their terms and conditions, and you might want to actually just ask that question to their support team because they probably just would be able to answer it. But probably the way it works on Canva is that their images, if you are a paying user of Canva, they're in that bucket of royalty-free images. So they're happy for you to use it without any attribution. That's my guess because Canva is a platform specifically designed for creating content. I suspect a lot of the imagery there is fine to use. It's only be if you were putting stuff in Canva that you got off Google Images or whatever it is, and you pasted it into Canva and then started using it. Well, that's not Canva's imagery, so there could potentially then be some infringement happening there. So yeah, I think that's how that works in terms of Canva. But again, it would depend on their terms and conditions, so probably just worth chatting to them and getting an answer on that. Does copyright risk reduce if the material content owner is formally cited? Not really, actually. A lot of people think it's like plagiarism. Oh, I attributed my source, therefore I can't get in trouble. Actually, that can have the opposite effect. It admits that you took it from that person, which is one of the things that has to be proven in copyright infringement, and B, it makes it easier for them to find you in a reverse search. You need to be careful. Really, the only way to make sure that you got permission to use a copyrighted works is if the person has given you permission or it's under one of these royalty-free things. Now, there are a few exceptions. There's things like fair use or like news content. There's exceptions around that stuff, or educational materials, not for profit, if you're using them not for profit or in a formal institution. There are exceptions that you can try and rely on. And some of them, attribution can help prove that it's one of those exceptions, like educational content. So there is a counter argument to what I'm saying. But in general, I think it's not best to rely on those exceptions because if you're really using it in business, it's not intended for you. It's intended for non-business uses. So yes, that's the answer to that one. What if you accidentally use someone's IP? Do you get sued immediately, or is there some time to take down work online? So accidental is not a legal defense. It does potentially reduce your liability a little bit if it's clearly not malicious, but it's still, you can be liable for without the knowledge that you were doing it. However, to your point, in practice, what usually happens for small businesses, you don't get hit with a squillion-dollar lawsuit. They don't want to do that to you. They usually just send you a cease and desist, and they say, please take it down right now, or we'll take further action. And I always advise small business clients, just take it down. Like, you don't want to get into a headache of having it go beyond this. So yes, chances are you're not going to get massively sued if there's one little mistake that you made. But you never know. Like, if you've really used a significant IP creation of someone and they care a lot about it and they have a vendetta, they might, and they would have the right to sue you. So it is possible. In practice, I don't see it that often, but it is possible. Alison said, photos and those of people in it are a nightmare. Could you talk through usage rights? Another great pivot to talk a little bit about privacy, which I'll do on our final slide coming up in a minute. Just to finish off though, first on NDAs, I won't talk about patents. Just to mention that people think that they're relevant to small businesses. Patents are really for inventions that you might make that, like scientific discoveries, like, the COVID vaccine or something would be patentable, or a really original piece of computer software or a robotic device. For most small businesses, they're not that relevant. So I actually just have this there because people often ask about patents, just to say, that's what they are. They're for inventions, and they're not that relevant for most online businesses, unless you're selling an invention online, in which case you probably know who you are and you've gotten some patent advice. NDAs, I just want to talk about real quick. People probably know what these are. These are non-disclosure agreements. They're another way to protect more business ideas and business strategies. If you've come up with some stuff that's original, it's not really copyright because it's not like an original work in material. It's not a graphic design or a written piece of content or a video, whatever it is, but it's still original and it's an important business strategy. NDAs are the best way to protect these, and basically they're just, keep it a secret, and before you tell anyone about this intellectual property, maybe it's your business strategy or concept, consider getting them to sign an NDA. Simple document. We have a free template on our free tier of our Sprintlaw membership if people want to grab one. You promise not to tell anyone what I tell you is what the document says. And if you do, you've breached this contract and you could be liable. So that's another tool in the world of intellectual property or intellectual property-esque things that's worth being aware of. We are just run up on time. I'm going to go for another sort of 5 to 10 minutes for those that want to stick around. There'll also be a recording of this on YouTube if people need to drop off. But I just want to talk about 2 more topics, including the privacy stuff and terms and conditions. So just quickly on this slide, for most online businesses, your key legal document, and I touched on this at the very beginning, is your terms and conditions. And I've got this dramatic title, Contracts Are the Lifeblood of Your Business. If you are selling products or services online, I mean, if you're selling them offline, it might be called a service agreement or a client contract. If you're selling it online, we call them, terms and conditions or client terms and conditions. These are probably the most important agreement for you because, this is the agreement under which every customer of yours is going to transact. They're going to be buying your goods. They're going to be buying your services in exchange for money. And it's going to be happening again and again and again. It's not a one-off thing. And so, this document is probably going to be your most used contract. And I do recommend most businesses, again, people often use online generators and things. I recommend most businesses get these checked or done by a lawyer, in part because in Australia, there's a lot of regulations on what you can put in these terms and conditions. The ACCC not only has the misleading and deceptive conduct laws, they have laws around refunds, around payment terms, around liability clauses, and a lot of templates you find online, breach these laws because they're American generated. Even the stuff ChatGPT might be making up for you oftentimes has American style clauses that don't work in Australia or particular states. And this is where we see the big risks, where people have no returns policies that break the law or liability limitations that break the law. Lawyers know what's normal and can really help you with these documents. So, it is one of the most important documents to think about. And if you're feeling like yours might not be robust, I would recommend considering a legal review for them. There's other contracts that can come up in your business as well with suppliers, they're selling you products, or service providers. These ones may or may not be high risk, depends on how much you rely on the suppliers or not. Again, you might have just signed what you were given. Might be worth having those checked and reviewed and making sure you know what you're paying for. You can get better deals with suppliers if you negotiate the contracts well. But again, it may be less essential than that client terms and conditions. But these are other legal risk areas in a business. Partners, referral partners, again, is an area where you can pay commissions or affiliate programs. There's contracts you can do there, and you want to be clear about how those work, how payments work. And again, if they're critical or lucrative, you might want to get proper contracts in place for them. So these are the kinds of contracts that arise in an online business. And again, terms and conditions being probably the most important. If you have business partners, up the top, we've got the shareholders. That's also a critical agreement. It's almost like the prenup or the marriage contract between the business partners. What happens if one of us leaves? What happens if the relationship breaks down? And so it's a really important contract that you might want to also put in place. And again, depending on how well the business is doing, I would also put that in like top priority category to get done right. So that's all I'll say about contracts for now, but hopefully it's pretty straightforward. Just finally talking a little bit about data and privacy. For businesses operating online, you just want to make sure you are complying with privacy laws. So there's really 3 things to keep in mind. The first is compliance. In Australia, we have the Australian Privacy Act. If you operate in the UK or EU, there's something called the GDPR. If you're in the US, there's something called the CCPA. But in Australia, we just have this thing called the Australian Privacy Act, which has APPs, Australian Privacy Principles. And there's a bunch of principles. And I have another webinar where I go into this in a lot more detail. But high level, if you're a business that's collecting personal information, which most businesses are, you collect people's names, phone numbers, anything that could be used to identify them is what the law considers personal information. If you're collecting that stuff, you've got to comply with the laws. Now, Australia has a pretty broad small business exemption. If your business, in many cases, if you make less than 3 million in revenue a year, which is a lot of small businesses, Privacy Act compliance is optional. You don't actually have to comply with the Privacy Act, which is might make you think if you're in that category, I can leave this webinar now because it doesn't apply to me. I wouldn't necessarily think that way for two reasons. One is if you hope to ever be above 3 million in revenue, it's a big pain in the neck if you weren't compliant before. To get compliant, you'll have to go get consents from all of your small customers. B, I expect that law to be abolished within the next 12 to 18 months. The government's already been recommended it by a recent Privacy Act review. So this small business exemption, which has been around for a while, is not confirmed, but likely to be gone. So, and also it doesn't apply to people that collect health information or sensitive information. There's a lot of exceptions to it as well. So it's not something to massively be relied on. So assuming the Privacy Act complies with you, or if you just want to comply with it because you're in that small business category, the main principle is when you're collecting people's personal information, tell them you're going to collect it, tell them what you're doing with it, allow them to contact you and ask how they're using it, and ideally request to have it removed, and so on. And you know, and if you are required to comply with the act, you can be fined or penalized for using people's personal information without their consent. Now, we had an earlier question about pictures of people. Yes, if you've taken a picture of a person, that can be considered personal information if it could be used to identify them. And if you haven't got their consent, potentially there's a breach there of some privacy laws. There could potentially be a breach of the copyright laws if you start filming someone doing like a dance performance, then you use that to promote your business, you haven't got their consent. That could be both a privacy and a copyright claim. So that's something that comes up often in creative contexts. And again, ideally you want permission. Now, like if you take a photo where there's some people fuzzily in the background and you could never really work out who they were and they're not doing a performance or whatever it is, the risk of you breaching privacy laws is probably pretty low because it might not be considered personal information, but it's theoretically possible. Best practice is to have, big businesses would have every single person in an image sign off on it, and smaller businesses would, I think, for big shoots and content, take some steps to get those consents, if that makes sense. But in general, in your business, on your website, you want to have what you have in the middle of privacy policy. You want to be saying, tick box whenever someone submits a form. By submitting this form, you agree to our privacy policy, and we may use that to contact you, send you marketing emails, et cetera, et cetera. And once you have their consent, you're allowed to do that stuff, but it's all about consent. You need to get that consent at some point. Finally, on the right, we have data breaches. Obviously, there was the big Medibank and Optus scandals in the last couple of years, and it's becoming a bigger issue with some new regulations. If you're in the category of having to comply with the Privacy Act, so above 3 mil or health information and so on, this is a pretty big area to be worried about. If you're in the small business camp, again, optional to comply with this, but still not a bad idea, and it might become more mandatory in future. If your business is subject to a data breach, someone hacks into your system, steals people's personal information and holds it ransom, you have some legal obligations. You have to try and figure out who was affected, try and notify them as soon as possible. You have to notify the privacy regulator in Australia. And if you don't do these things, there can be fines and penalties for you. So again, probably deserves its own presentation, but the main takeaway here is if you do suffer a data breach, be aware that there's some time-sensitive legal stuff and you might want to get on some legal advice pretty quick to make sure you're on top of it. So we got a little bit over, but I think we covered most of what I wanted to cover for today. Jacob's asked with patents, if we design a product, would a patent protect the product? Not unless it was a real invention. There's another type of IP I didn't mention called design registration. So if you design a piece of furniture or like a mug or like a new object with a new shape, you can protect that product design through IP Australia through a design registration. That would be the appropriate IP protection for product designs. So maybe have a quick Google of that if that's something you're interested in. But patents are really for inventions. Like I said, pharmaceuticals, machinery, like real scientific inventions, not really product designs. So yes, if anyone needs legal help, we have on screen a link you can scan to book in a call with our team. Otherwise, feel free to reach out to our team and mention that you came to the webinar via our website. I hope people have found this useful and helpful. We do these every month, so hopefully we'll see you in future. And if there's topics you'd love to see us cover, do let us know. Otherwise, it's been fun. Thank you for attending, and all the best, everybody. Bye-bye.